Welcome to the Ripcord Moment. I'm your host, Joe C2. Today, I'm joined by Meredith Sesser of Sesser Law. She's one of the nation's leading authorities in employee benefits law and ERISA law. She's got over 20 years of experience working with businesses and nonprofit organizations. So she often is brought in with companies to help them prepare, implement, do the operational due diligence, and also termination of retirement plans. These could be cash balance plans, defined benefit plans, your typical 401k profit sharing plans, and also 403b plans. She also specializes in dealing with controversies related to Department of Labor matters and IRS matters related to these plans. So in addition to working with the employers, she also helps employees understand their benefit claims, and she's really the go-to lawyer for third-party administrators who help administer retirement plans. Meredith, welcome to the Ripcord Moment. I'm really excited about our discussion today.
Thanks for having me this morning. It's always good to see you.
Great to see you. So you have a really sort of niche practice, highly specialized at the intersection of law and these retirement plans. Obviously, it's such a specialized area, a lot of law that goes into that you have to really know here. What are the common operational failures or situations that come up that you notice when a company is thinking about selling?
So, yeah, I am a lawyer that practices in the area of retirement plans, which is governed by ERISA. And people might have heard ERISA before, and that was passed in 1974. It's the Employee Retirement Income Security Act. And those are really complicated rules which govern these retirement plans. So when a company is going to sell, I often get brought in to do a review of the retirement plans, and I tend to see the same failures over and over again. One of the most common failures in, let's say, a 401k is when the employer withholds the money from somebody's paycheck to put in the 401k. Yep. And for whatever the reason, it just doesn't make it to the plan. And I don't know how that happens, but sometimes it comes out of the payroll, and it will sometimes end up in the company's account because they need the money. Or sometimes it ends up in just a checking account and not the 401k plan account. And so those are what we call missing deferrals or late deposits. And those are very common in 401ks, unfortunately.
Really? Okay.
Yes, you would think if you're running payroll, it's really simple to just withhold the money and remit. But sometimes it doesn't happen. Maybe someone in HR forgot, or they were on vacation and they took the money out but never sent it to the plan.
And is this, real quick to interrupt, Meredith, or jump in here, but is this like with typically just more like startup type companies or smaller companies? I mean, I would think larger, well-established companies that this wouldn't be a common issue, but maybe that's not the case.
It happens. I actually have a car dealership client, and he has a couple car dealerships, and it happened there. And I asked, how did the money go in late? Well, they had a change in the HR department, and the new person didn't know that was their job and they were to do it, or they didn't know where to send it. So it went through payroll, but it didn't go somewhere. So once it gets automated, it's pretty simple. But for whatever reason, this failure happens a lot in large plans as well as small plans, when maybe the owner of the business is the one who's responsible and he just gets too busy and doesn't click send.
Yeah.
So it does happen.
You bring up an interesting point because you said the word automate. Once it's automated, right? And so that's one of the issues I think many owners go through as they grow a business. Right, they're doing oftentimes things that are so manual, and if it lives in their head or it lives in the HR person's head and they don't communicate that clearly, or it's not a process that's in place, that it's documented, errors occur. And then,
Yeah. And back in the day before, the internet, the business owner would actually write a check and put it in the mail and mail the 401k deposit in. And Department of Labor said, it's got to be in a week. Well, with today's mail, it may not, if someone mails it, It may not come in a week. And therefore, you have to have automated systems, and sometimes they fail. And that's one of the failures we see on 401k plans. Another failure that we see would be where a company thinks their plan says one thing and they're doing something that's not really in the plan. So I had a client, an engineer client, who sold his business because he was retiring. He and his partners, and they were being bought out by another company much larger that really did their due diligence and reviewed everything. And they found some employees who were actually in the plan, and the plan document did not provide for them to be in the plan. They shouldn't have been in the plan.
They were enrolled, but they should not have been in the plan
Correct.
based on the guidelines of how the plan was written.
Yes. And I've also seen the reverse where people exclude employees from the plan saying, well, they're part-time or they only came in, I paid them hourly or whatnot. And so they excluded them, but they should have been in the plan. So those are mistakes you can find.
Now let's take that a level deeper, which is what is the impact that this has on the business owner? What sort of liability do they face? What penalties are they dealing with for being out of compliance?
So being out of compliance means a few things. One, there's a cost to correct. So in the case of not putting someone in a plan who should have been, the IRS requires the employer to come up with the money to put in for that employee. And so there's a cost to that, plus interest on the late money that should have gone in. There can also be excise taxes if the IRS says it's prohibited. The worst case could be the IRS says the 401k plan is not even qualified and all the money's taxable is income.
Oh, wow.
Yes, that would be the worst case scenario. Yeah. And you don't see it often, but that's because people fix the problems. So when you're going to market to sell, you want to see these problems and know what's my exposure, what's my liability, what kind of penalties am I looking at, and things like that. So therefore, you would know my company may not be worth what I think it is if I owe $1 million to my 401k.
Absolutely. Well, so you this is a great segue to the next question, which is what sort of pre-due diligence, right, should the owner themselves do on their retirement plans ahead of the transaction? Because a savvy buyer is going to look at their potential exposure here.
Yes. So generally the buyer has counsel and they're going to ask for a slew of documents and they're going to look at it and look for any area of exposure in terms of a participant suing, in terms of the IRS or Department of Labor assessing penalties. And they're going to try anything to look for anything that's wrong, that's going to cost them money down the road. May not be an issue today, and maybe the IRS didn't catch them yet. But if they get caught, it's going to cost money. And nobody wants to buy a company unless they're aware of these issues. So what we recommend is that before you go to market, the seller should do a due diligence review. Hire an ERISA lawyer, get all the paperwork together, look at it and see what's going on. No different than a wealth manager would want to look at the assets of a company, right?
Sure. Yeah, absolutely. So it sounds like you're saying essentially do an audit. Audit the plan. Do an audit of the plan to make sure there's not hidden errors that are going to come back to maybe blow up the deal, or if the deal gets done, come back to be, some sort of liability that's hanging over the seller.
Now, personally, as an ERISA lawyer and not an M&A lawyer, I would hate for a 401k plan to blow up a deal going through. And so my goal is always to find a way to make sure this deal goes through and take the 401k out of the picture. So often you can say, you know what, we're going to terminate it before we close, sell the company. We're going to fix it before we sell the company. We're going to spin it off to another company so it's not the buyer's problem. So there's ways to deal with it if you know it's there.
So you bring up an interesting point, this idea of having to deal with it and some of the remedies there, like maybe going and terminating the plan. But with what has been passed in California with the new requirements for businesses through like the Cal Savers program to offer mandatory retirement plans for businesses to their employees, how does an owner navigate potentially shutting down their plan while they're thinking about selling their business, but still be in compliance with the new California laws?
Yes, it's interesting. We sold a company, or I was involved with the sale of a company this year, and the client did not have a retirement plan, which, as you know, in California, they needed to have one and should have signed up for Cal Savers. So we immediately got them enrolled and started the plan so they could, at least when they sold, say that they had it. So if you're going to terminate a plan prior to close, then there needs to be something in place that these employees are going to go into, whether immediate next payroll is the buyer's plan, so they're covered, or maybe you set them up with Cal Savers. California just requires any retirement plan, whether it's theirs or a controlled group or a parent company, but you have to offer something right now, 5 and more employees.
Is there a grace period between in the example here where one company is being bought by another, you're shutting the plan down. Beyond one payroll period, I mean, are you allowed a 30-day grace period or a 60-day grace period or no?
Cal Savers has not addressed it as to at what period of time you can be without a plan. But
Okay.
typically, if you had a plan, you would have filed with Cal Savers to say I'm exempt, meaning I don't have to do Cal Savers because I have my own plan.
Right.
Now, if the employees are going to switch payroll, they may have to wait 30, 60 days to be eligible for the buyer's plan. So that would be legitimate if they have to wait a waiting period.
So you're saying you would be covered. They would be okay in that.
Yes, because the word is not participating from Cal
Mhm.
Savers. The word is that they have to have the opportunity or
Oh,
to participate. So if they're going to be offered the plan at some later date, 30 days, 60 days, that would be sufficient for Cal
okay.
Savers, I would think. Yeah.
In addition to sort of the audit that we just talked about, what are there any other due diligence steps ahead of the transaction owners should be contemplating on this matter?
Yeah, absolutely. It's not just the 401ks. In the reps and warranties in the sales agreement, they will ask about all retirement plans, non-qualified retirement plans,
Okay.
types of money you might have said to your employee, your head of your company, if I ever sell, you're going to get this big payout. That could be considered deferred compensation. If somebody is going to get certain health benefits, they want to know about health benefits, premiums. So it's all benefit plans that need to be looked at that the M&A lawyer should request and have an ERISA lawyer review. So
Okay.
it's quite a bit. It's usually only a page and a half of 100 pages of the agreement. However, it's an important page and a half to read of all benefits.
And when are you? It sounds like you're collaborating oftentimes with the transaction attorneys during the
Absolutely.
deal to help form the reps and warranties. Is that a correct
Absolutely.
assessment? Yeah.
So the way that these things work is that the M&A lawyer brings in me as a ERISA counsel to look at the benefits section, and they
Right.
bring an employment lawyer to look at the labor and employment section. And sometimes we'll cross paths. You know, if somebody is a 1099 but should have been maybe a W-2 employee, what does that mean from an employment standpoint? And then what does that mean for the 401k? Should they have been offered the 401k and they weren't?
Yeah.
So, you know, there's a lot of issues that can come up, and the employer doesn't always know they did anything wrong. It's just
Yeah.
the way they do business.
Yeah. They've got a gazillion things going on.
Yes.
They're assuming, they meet with their third party administrator once a year or the email, and they think, they've got an HR person who's handling all that. They think they're in
They
compliance.
think it's covered.
Yeah. They think they're covered.
And it's not until you go to sell the company and you audit your plan that you sometimes find these nuances that people just don't know. And
Well, the laws change over time, right? And,
the laws change. Sometimes someone, the buyer will ask for an amendment and the employer never did it because they just didn't know. No one gave it to them. Or maybe, little things. There could be little things that come up.
So I think we've talked about the due diligence ahead of time. We understand your role in working with the attorneys during the transaction. Let's imagine there is some sort of big red flag in the negotiations while the transaction's going on. What are some of the tools in your toolkit that you bring to the table to help get the buyer off the hook or get it ready?
There's several. Yeah, there's several. You have to have something in your back pocket to make sure this deal goes through. That's my goal. And one right now, the employer has a pension and a profit sharing plan. And because of the market, the assets have gone down quite a bit.
Yep.
And he's not in cash, he's in the market.
Sure.
And he's about $900,000 short in the plan.
Meaning it's underfunded by that amount?
Underfunded, about $900,000.
Yeah.
And so we're adding in a rep and warranty that says it will be held in escrow because we can't pinpoint the money. If the assets go up, maybe that 900 goes down to 800.
Okay.
But if the assets go down, he may be on the hook for more, and the buyer doesn't want to be on the hook for that. That was his plan.
Yeah.
So we'll put in escrow a little bit more and make a deal that says he'll fund this thing and it's his responsibility.
And are you carrying back some sort of, is there like a note that's attached?
Yeah, it's in escrow and it's on writing that says he will get back the difference. And if we estimated wrong, he's liable to fund that amount because these were his plans and they don't want them.
But I guess my question is, are they, in an example like this, is the seller required to fund escrow 100% by the closing?
He is, and
Okay.
we will have it in escrow by the closing, which
Okay.
will hopefully be in the next week or so.
Yeah.
That's a simple thing to fix. The harder ones are when you need IRS approval. And so
Mm.
often what will happen is we will go to the IRS and say, we screwed up. We know we screwed up. We're coming to you before you catch us, and we want to fix this. And for a small fee of maybe $3,000, you can enter what they call a voluntary correction program. And the
Okay.
IRS will look at your mistake and how you propose to fix it and say yes or no. And then that will give the client a letter that says, yeah, you fixed the plan, you're in compliance.
Let me just pause you there real quick because this sounds a little more complicated. Is that a
Yes.
situation where you're making that recommendation, or is the buyer imposing this on the seller as a condition for closing? How does that work?
Usually it works both ways. Often the buyer will say, we know you have this liability,
Okay.
and therefore we want you to go fix it. And so
Mm.
we'll propose it and say, we want your sale to go through, so we will go fix it. Sometimes it's as silly as I've had a client that they had multiple companies, and one of the companies forgot to sign the plan document, but yet their employees were in the plan. To be in a plan, you have to actually adopt it and sign it.
Sure.
So it could be as silly as they didn't sign it. They just nobody told them they had to sign it. So we would go to the IRS and say, we're sorry, but we have this subsidiary. They're in our 401k and they never signed it. We're going to sign it now, 5 years late. Is that okay? And they
Hmm.
say, yes, sign it now, 5 years late. Now we fix the problem, and the buyer's happy because the problem's fixed. If you didn't fix it, then the IRS could argue they should have never been in the 401k because they never signed it. So now
Right.
you have 5 years of contributions that weren't allowed,
Yeah.
all because this client didn't sign the plan. Happens with a lot of times with doctors if they hire a new partner and the
Hmm.
new partner is incorporated. So you've got a partnership of medical corporations. And now a new doctor comes on, a new partner, and he wants to be in the plan and contribute, but he doesn't sign up for it. He doesn't adopt it officially, but yet he's putting money in. That
This is
happens.
where we have to have really good third-party administrators,
Yes.
right?
And you have to call them to tell them we have a new
Well,
partner.
there's got to be communication between the
Yes. So
client and
sometimes it's both
their
ways.
advisors. Absolutely.
Yes, the administrator's like, I had no idea you had a new
Sure.
partner.
Yeah.
And then if I knew, I would have given you the papers,
Yeah.
but they don't always know. And
Okay.
so basically that can be fixed. And a buyer is going to see that right away that, it's missing.
Have you seen a situation where the errors were so, I guess, egregious, or they were just so bad that it actually blew up a deal, an acquisition or a
Close.
sale, or close?
Close.
Okay.
I did have a bookstore. It was a small bookstore owned by an individual, and she was retiring, and she
Hmm.
had a pension plan. And for whatever reason, there was the liability, if I recall, was $7 million. So that was a huge amount of money that this pension had $7 million owed to it. And the deal was off the table. They said there's
Wow.
no
Yeah.
way. And so we ended up being able to use another corporation of hers to take that plan, so
Okay.
that when the company was bought out, there was no plan anymore. And we dealt with it somewhere else. So
Hmm.
she funded over time, but
Okay.
almost off the table as soon as the buyer heard that number, because
Got
that's a huge liability to take on for a bookstore or for any company for that matter.
Well, you bring up the word liability, which I want to pivot to our next question, which is we talked a little bit about fees and penalties, but what kind of exposure does a company have for these failures related to a retirement plan? Because the owner is a fiduciary, correct, right? To
Absolutely.
the plan. So, yeah, let me
You have
turn it over to you.
fiduciary liability.
Okay.
You have fiduciary liability for choosing investments. If you're choosing bad investments,
Hmm.
sometimes clients go outside the funds and buy startups or real estate or things that just tank that what they didn't look into, but their next door neighbor said it was a good investment, so they relied on them and bought it. So you're a fiduciary to that and could
Right.
be liable for losses.
Uh-huh.
I have a guy now who's liable for $450,000 in investments he made with everybody's money that he never really researched, and it didn't perform. And it's been 10 years and it's earned zero. It's
Wow.
worthless. So he had to restore that. There's
Now, was this in a
liability.
DB or a DC type plan,
It
if
was
you
a
don't mind
profit share. That was a profit sharing
my
plan.
Was it? Okay.
Yeah. And it just, about $1 million in assets, and he took half and loaned it to startups that just never performed.
Wow.
Yeah, and you can also be liable criminally, which is shocking because you wouldn't think 401k in criminal, but I do have clients that if they steal money from the plan, so they're
Hmm.
taking it out of 401k accounts because they're the trustee and maybe using it personally, that's theft.
Yep.
Or if you refuse to pay employees because you don't like them. Sometimes people say, well, this employee stole from me, so I'm not going to pay them their benefits. And if you don't pay them and take their money, that can be theft also. So there's all different liabilities, whether it's monetary or criminal or fiduciary breaches. So even though it's just a 401k, it's a big deal and it's got
Yeah.
liability with it.
I mean, ERISA law is very nuanced, very specialized. But
Yes.
it's certainly, I think, an area of the law that when they put it in place in the 70s was really to protect employees. And so I think that speaks to what you're talking about, that,
Yes, it's about the employees.
yeah,
And we don't want to
exactly.
steal from the employees. We want to protect the employees. We want to invest their money prudently, and
Prudently.
we want it there when they retire.
Yeah. Well,
Yeah.
Meredith, gosh, our time goes by so quick here. We call this the Ripcord Moment because I'm a firm believer that when an owner goes to sell their business or some sort of succession event, that it is a once in a lifetime event for most owners, not all, unless you're a
That's
serial
true.
entrepreneur. And it's like that ripcord just can't fail. And this is certainly an aspect of their business that impacts not only them, but their employees, their staff. So what are two takeaways that every owner should contemplate doing sooner than later if they're going to have some sort of succession event?
So, two takeaways as an ERISA lawyer to a seller is engage ERISA counsel just to do that due diligence review so that you can make sure there aren't any liabilities or fiduciary breaches or unknown costs or something hanging out there that's not in order. Because if you can do it before you go to market, it can be fixed. And when the buyer comes in, they're not going to see anything. They'll see that there was a mistake and it was fixed.
And let me ask you on that, because I know one common thing I hear from owners all the time is I've got a million things to do. This is
Yes,
not the top of my priority list. We have an HR, whatever. You hear all the excuses, but so just
absolutely.
maybe quantify for the audience, like what does an audit take in terms of roughly the amount of time?
So
Um,
generally, I have someone set up a Dropbox and just throw everything 401k, pension, profit sharing, retirement related in there. And
okay,
that's all they have to do.
that's all they have to do.
Just throw all that in there, even if it's more than you think. And then as a lawyer, I can go through everything, and it may only take a few hours to go through it
Okay,
and pinpoint something that I see that this doesn't look right.
all
And if
right,
it doesn't look right, then it can trigger more questions.
yeah, but
Because what I'm seeing is what the buyer is going to see, right? And
absolutely, yeah.
looking at the same thing. So,
Yeah. Now, where I'm going with this is, and I think you hit the nail on the head. It very well may be not as onerous of an audit that they
yeah,
might think. Sometimes people hear the word audit and they're thinking this is going to take weeks and hours and too much of my time. And um,
no,
an ounce of prevention could be worth a
it
pound
could be
of
worth a lot of money.
flashlight
Right.
later on. Exactly. Yeah. So, all
And then
right. So that's
the
what
second
that's
takeaway.
one. So, yeah. Your second
The
takeaway.
second one would be is that once you do that due diligence review, if there is a problem that you find or an operational failure, fix it and take care of it before you go to market. That way it's fixed and it's going to cost a lot less later on if somebody sees it. It's
Yeah.
always better for the client to go clean and say, I made a mistake than for the IRS to catch it later.
Yeah. All right.
The sanctions are much more later on. A few $1,000s to fix a mistake versus 25,000 later is a big difference.
Yeah. That's a
So
huge
those are
difference.
my two takeaways.
Okay. Meredith, that's sound advice from a true expert.
Thank
Really
you.
appreciate you taking the time today to be with us and explain, some of the nuances related to retirement plans and ERISA law that many owners are going to have to deal with. So,
Thanks so much for having me,
and
Joe.
real quick before I let you go, I was noticing the art behind you. I love it. Give
Thank
us a little
you.
bit of a background on what that is.
I love it. I have absolutely no idea what it is, but I thought that it looked nice on the wall behind me. So
There you go. Yeah.
maybe it actually means something. Not sure. We'll
Oh,
figure that out next time.
that sounds good. That's great. Well, we're going to go and sign off from the Ripcord Moment. I'm Joe C2, and we'll catch you next time.